to Bodacious Estate Conversations, the podcast where we skip the polite small talk and get straight to the real story about handling a loved one's property. From unexpected challenges to the messy emotions nobody warns you about, I bring you unfiltered stories, practical advice, and clever shortcuts from people who've been there and the professionals who know the way. If you want honest answers, bold strategies, and the confidence to take control, you're in the right place. Here is your host, Casey King.
Thanks for tuning in. On today's episode of Bodacious Estate Conversations, I'm so excited to welcome our guest who spends his days helping homeowners, developers, and families navigate some of the most complex and misunderstood parts of real estate law. He's a partner at Barley Snyder, where he focuses on real estate transactions, land use, zoning, and planned communities, including condos and HOA, which can quietly derail a sale if you're not careful. Outside of work, he enjoys spending time with his family, hiking near the river, and surprisingly, raising backyard chickens. Please give a warm welcome to Reilly Noetzel. Thank you so much for joining us today, Reilly. I'm so glad to have you here.
Yeah, thanks for having me. I look forward to talking to you today.
It's going to be a great show. So today we're talking about the hidden legal issues that can stall or completely kill a home sale, especially when someone is dealing with an inherited property, a condo, or an HOA. Stick around until the end because we're going to share one issue that he sees coming up after a contract is signed when families think they're in the clear but can still blow up a closing. All right, well, let's just dig right into it. So I work with a lot of families who assume selling a home is totally straightforward, right? Like list it, sell it, and then move on. But from your perspective, kind of high level, what does the actual process look like?
Yeah, no, that's a good question. I think, I work with a lot of estates and executors who are kind of looking at the picture holistically, trying to figure out like what is the first step that I'm supposed to take to get this process moving. And I usually say it's a good idea to make sure that you have a really good team in place. As an attorney, I see a lot of benefits in having good legal counsel in the process. We can certainly help with reviewing contracts, documentation, making sure everything's kind of in order and you're meeting your obligations in terms of, selling the real estate. But then also having, a good broker, real estate agent who can help kind of advise you on, market prices, what the market looks like, what you realistically could expect in terms of, buyer interest. And then also having a good accountant involved just to make sure that you're crossing your T's and dotting your I's in terms of any tax implications, any impact that may have on the estate, especially if it's a more sophisticated estate that has a lot of assets. A lot of times there are tax implications that you have to consider as well. So assembling a good team is really the first step. And I think then going from there, it's sort of developing, a game plan or a strategy in terms of how you'd like to see everything play out, what your timeline is, when you realistically expect to kind of have the home cleared out. For example, there's often a lot of, personal property that's still left behind. You have to get the property ready to be kind of marketed and shown. So it's important to have a clear timeline on when you realistically expect to kind of have all of that completed, and when you would like to have the home, sold and settled.
For sure. So I love that because everything that you just said, not the accounting side, but from like the real estate side of things, my team helps with. So from going through and first figuring out from our perspective, who is the buyer? And that's going to be based in large part of the condition of the property. If it's move-in ready and in great condition, the buyer is going to be somebody that plans on living in it. But every once in a while, we get properties that are in really poor condition. And that buyer is probably going to be an investor that plans on rehabbing it to bring it up to livable conditions and either rent it out or put it back on the market. So the first step from the broker's perspective is what's the condition of the home, who identify who the potential buyer is going to be, and then based off of that, what the market value would be from there, and the proper marketing plan too.
Yeah, I often have a lot of clients asking like, do I need to have an appraisal? Is that something that I need to like know what the value is? And that's where kind of someone like you and your team would come in handy because you know off the top of your head like what the market is, what realistically could be gotten for the property in terms of a sale price. So I always say you don't need an appraisal. You just need to have, a good broker on your side or someone familiar with the market to kind of tell you what you realistically could get for it. And some, executors that we work with and estate administrators are kind of willing to invest a little bit to rehab to not necessarily do a full scale renovation, but just minor cosmetic adjustments and
Yeah,
cleaning out the personal property can even add value just in getting good pictures of it for the listing.
absolutely.
So if you're willing to kind of spend time and money to do that, it can pay off in the long run. And that kind of goes back to what I was saying with the timeline, just making sure that you're kind of understanding what the timeline is. If you're the estate that you're kind of administering or you're serving as the executor for is, cash poor and there's not a lot of assets and this property is the one thing that once sold can kind of help close things out, it might be a little bit more of a quicker timeline. But in other states, you might have more time on your side,
Hmm.
and it gives you the ability to kind of renovate or do some tweaks and touch ups to make it more marketable. Um, the other thing I'll say too is that it's important to understand, just the property itself. So um, a lot of most executors don't live at the property that they're working to sell. They may be familiar with it, they visited it, it's a loved one's home that they may have spent a lot of time at, but they may not know the ins and outs of, the property. So for example, knowing if your property is part of a condo or HOA, knowing what the zoning is for the property, knowing the utilities, how is it heated? Is it public or private? Septic, water, sewer, like how is the property served by these utilities is going to pay off in the long run because all of those things are issues that are going to need to be addressed one way or another prior to settlement to make sure
Hmm.
that the title company has, all the information it needs to kind of switch accounts over, pay off any assessments in terms of an HOA or condo. So kind of having that framework up front helps in the long run because it'll help structure the contract, the ultimate contract with the buyer, making sure the appropriate provisions are in there, and just kind of knowing the background and you know overall structure of the property is helpful up
Yeah.
front.
So, do you see, like commonly throughout the transactions that you deal with, some things that come up that sellers don't realize they're responsible for?
Yeah, actually, quite often. So, for example, like there's often a question in terms of estates, like whether or not what you have to disclose to a buyer
Mhm.
in terms of listing, and there is a seller's disclosure law. I'm sure you're aware of that. That sellers have to disclose what they know about the property, but there is an exemption for estates and estate administrators. So technically speaking, if you're an executor, of an estate and you're working to sell a property, you do not have to complete a seller's disclosure form. That being said, I always do tell the clients that I work with that if you know something and it's a material thing, you're probably better off to disclose it in writing in the agreement because the last thing you want to do is go through a settlement or get close to a settlement and have the buyer either pull out or at the end you sign all the paperwork and 2 weeks later the buyer comes back and says there's this major leak, there's mold, I think you knew about it or you should have known about it and you never told me, and then you're fighting about it after the
Mhm.
closing and spending the money that you made from the closing on legal fees and court costs to battle that issue. So one thing that I always tell clients is, just if there's something it's better to just disclose it upfront in writing so that there's no question and the buyer is aware when they're signing what they're getting into. I recognize
Mhm.
that, the seller's disclosure, there are exemptions for estates, but I just feel like from a practical perspective, it's always better to have everything disclosed up front so there are no surprises. So
Yeah.
that's one thing that we often see.
I totally agree with that. And when I try to explain it, it's like You're exempt because you don't actually live in the property, so they're not expecting you to know every little thing about it. But if you know because you overheard, mom and dad talking about replacing the roof 5 years ago, just note it. It's better to be safe and disclose it versus exactly what you just described there.
Yeah, and even things like, septic and wells, sometimes we run into a lot of issues with that where, a lot of homes, especially in rural areas, might have a septic system that hasn't been fully permitted, or it might just be very old and there's not a lot of paperwork on it. And there are certain disclosures and things that have to go in your contracts if it is, an on-lot septic system by state law, things, special provisions that have to go into the agreements. And I always explain to clients that are sellers of properties that have septic systems, like, this is what this disclosure says. Just make sure if you have paperwork on it or documentation on it, that you're giving it to the buyer. The buyer may want to do their own due diligence on the septic system, but there have been situations where I've run into where we're trying to sell a property and it has a septic system that hasn't been, fully inspected or properly permitted. The buyer goes to kind of get more information from, the municipality about it, and then it flags in the municipality's mind, oh, we don't know anything about this, or that's not what our records show. And then you kind of run into a situation where, to your earlier point, the sale gets stalled or terminated in worst case scenarios because you're running into municipal approvals or issues where
Mhm.
something wasn't properly permitted. It has to be corrected before any sale can occur, and that does affect the marketability. So it goes back to what we were saying, where the more you know about the property up front, the more documentation you have before you go to list it, kind of helps you hedge your risk and understand, like, where are the possible issues where this could go awry.
Yeah, absolutely. I've even done home inspections, pre-listing home inspections. So
Hmm.
the seller will have it inspected, and then for the disclosure, we just put a notation: "See attached home inspection." So whatever the inspector finds, that we attach it to the disclosure.
That's a great practical tip as well. Again, going back to just knowing kind of what you're dealing with up front is always better.
Yeah. Another thing I found that sellers don't typically realize in if their agent doesn't pony it up for them is that when a buyer is doing their due diligence on a well and septic, the seller is actually responsible. If, let's say, the well is buried and they don't know where it is, the seller is responsible for figuring that out. So if you have to hire a professional to figure out where the well is and unbury it in order for it to be inspected, the seller has to pay for that. And then also with the septic system, when that's being inspected, it has to be pumped out. And
Mhm.
guess who pays for the pump out? The seller. So
And those are all things that, you and I both know with, like, the standard agreements. It doesn't go into all this detail of what happens. There's no way in a contract for
yeah,
every possible scenario to be documented. So that's where, having the good team on your side to kind of advise you of these potential issues is really good. And you can always amend the agreements and, the contracts to address certain responsibilities and negotiate some of these issues. But to the extent that you can kind of put them in up front or predict some of that, it can go a long way.
yeah, for sure. Okay, so the high level process. So we got a team together, we marketed it, we got a buyer that gave us an offer, we accepted it. The buyer does their due diligence. What comes next? Let's say the buyer finds a few things that they're unsure about. What could come next in the process?
Yeah, so it depends on how your contract is structured. There's a lot of different ways you can set it up where there's, a specific due diligence period and the buyer can come back to you during that time. You can set it up as an as is, where is, so there's not a whole lot of wiggle room for the buyer to kind of adjust things. But typically, there is a due diligence period. And I always tell clients, as long as a buyer has a deposit kind of paid, earnest money deposit paid, they're going to have an interest in coming back to you if there's any sort of issue that comes up through the due diligence process, and you try to work that out through an amendment. So oftentimes it's, they come back and find an issue with, let's say, the septic, for example. there's something that needs to be done, a new component that needs to be replaced. They do a septic inspection, they figure out what that is. They'll often come back to the seller with a report that evidences exactly what it is that they want to see done. And then, because again, the contract can't possibly speak to these issues, you often enter into a negotiation of an amendment, an addendum, in addition to the contract that was signed that basically says, here's how we're going to handle this issue. So it might be a purchase price reduction to account for the cost of the work that needs to be done. It might
Mhm.
be an agreement that the seller will do the work and here's the time frame for getting it done, and we'll extend settlement to accommodate that work. It might be that the buyer does part of it and the seller does part of it. There's might be a cost sharing. So oftentimes, to your earlier question, when a buyer comes back with an issue or something they found during due diligence, it results in a negotiation of an amendment. Um, and usually both parties are somewhat interested in finding a resolution because they've made it this far. There's earnest money on the table. The seller obviously wants to get the house sold. Um, so oftentimes it results in a good faith, negotiation and a signed amendment that allows both parties to move forward. Although in other occasions, it does lead to a termination of the agreement, and that's where I
Mhm.
go back to, depending how the contract is written, the buyer's ability to get out of the contract can vary. So if it's an as is, where is sale and they've waived all their inspection rights up front and they just so happen to find something on their own, the buyer's ability to come back to the seller and terminate and get the deposit back is limited, unless they can show that there was some sort of default on the part of the seller, and that would basically be again a misrepresentation, something that they can show that the seller was supposed to do or explain to them and never was explained. Those are kind of the limited scenarios where they could, theoretically terminate and get the deposit back. But in an as is, whereas sale, typically the deposit, would go to the seller if they terminate. Um,
Mhm.
if it's more, again, the other scenario where there's a due diligence period and they're within that, inspection or due diligence period, there's often more of an ability for them to just walk away because they're just not happy with what they found.
Yeah.
Um, the other thing I would add too, speaking of deposits, and sort of another issue where things can get a little hairy is you often, when you sign these agreements as a seller, you kind of think of it very simplistically that the deposit is held in escrow. If the buyer walks um, during their due diligence window, they can get it back. If they don't, it goes to the seller. But 9 times out of 10, even if the contract is very clearly stated that it goes to one party, you still end up fighting about the deposit if there is truly a
Mhm.
termination and the parties don't agree, because the escrow agent, usually a broker, can't really release it if there's a dispute about it.
Right.
So a potential wrinkle in these types of transactions and what can kind of hold up a property, or one example of something that can hold up a property in a sale, is that a buyer does decide to walk and the seller doesn't feel that they're entitled to do so, and there's a dispute over who gets the deposit. Oftentimes that is resulting in mediation, dispute resolution, maybe even court over who gets the deposit, which, while all of that is going on, means that the property is just sitting there.
Yep. Yeah, for sure. I get so sometimes when, um, let's say the buyer finds something and they want to renegotiate to cover the cost of the repairs, sellers kind of freak out because they don't have the funds to do the repairs themselves before closing or the timeline or whatever it is.
Hmm.
So, one of the resolutions that I found to work most of the time is to agree to hold the seller proceeds in the cost of whatever the repairs are going to be. So let's say the repairs are $10,000 is what we have quoted. Great. We'll take the seller's proceeds. So after closing, hold it in escrow and pay the contractor directly after the new buyer takes possession. That way, it's not an upfront cost
Hmm.
from the sellers.
Yep. And I think the escrow agreement that you enter into for those sort of proceeds should be very clearly delineated as a seller as to what the obligations are, and what the timeline is for it.
Mhm.
You don't want to commit. I'm sure you agree. You don't want to commit as a seller to doing something within a time period that's unrealistic, because if you don't comply with the escrow agreement, then basically the default is that those funds then go to the buyer to do the work instead of the seller. So it's
Yeah,
important to make sure that those agreements are structured carefully so that, as a seller, you are in a position to get that done in a timely fashion, and also get the money at the end of the day.
agreed. Yep. Okay, so going through the process. So buyer's due diligence is complete. We did a renegotiation if necessary. So now we're moving forward to get to the closing table. What comes next?
So again, going back to having all your documents in order, you're going to be dealing a lot with the title company, the buyer's title company, that is going to request various things to make sure that they're prepared to, proceed to closing. So with an estate, they're going to want to see evidence, certificate of death, all the estate paperwork, the letters appointing who is actually the executor. Um, Anything that is indicative of how this property is supposed to be handled. So sometimes they will need to see the will, that if it's a trust, they'll need to see the trust documentation. So making sure you have all of that ready to share with the title company is going to be crucial, and you're not searching for all of that at the last minute.
Hmm.
If there's a mortgage that needs to be paid off, you'll need to interface with the mortgage company, and the title company will need to do so as well to get a payoff, so that gets addressed and handled at the closing table through the title company. If there's public water and sewer, oftentimes the title company will have the executor work with the municipality or whoever provides those services to get final meter readings. And sometimes the meters aren't where people think they are. So oftentimes you need, a couple days to figure that out, and they need to be timed so that they're accurate enough for closing, but that they're not, you're not rushing at the last minute to get them. Because I've seen situations where the meters aren't accessible and you need to coordinate and get someone to help you get to them. And depending on if the property's in an urban area or development, can kind of impact how you get that information.
Hmm.
So all that being said, you'll be corresponding with the title company, getting them information, documents that they need. Um, the other thing too is just making sure that if it is, a condo or an HOA, that the home is in, you'll need to coordinate with the homeowners association or the condo association to figure out what the assessments are that need to be paid up to closing, and making sure those get prorated between buyer and seller. There's a document called a resale certificate in those
Hmm.
situations where the association needs to furnish all of that information to the title company and to the buyer, indicating whether there's any issues with the home, any defaults or breaches of the deed restrictions that might apply, any past due assessments. So you'll have to request all of that from the association, and oftentimes there's a fee for that. And it's good to get that at least 30 days or so in advance of closing, so that it's accurate. So the time period between due diligence and settlement is really kind of what I call buttoning up, getting all the documents in order before you go to settlement.
Yeah, that's another thing that sellers don't realize they're paying for is that resale certificate, which can be a couple $100s.
Yep, it can be, and it takes some time to get, depending on who the manager is, and that's goes back to my earlier point of kind of understanding the property, knowing who you might need to reach out to. So in a condo and association situation, knowing who the property manager is or who the point of contact is going to be crucial, because you're going to have to be the one to reach out to them. Oftentimes, you have to let them know that the property is being sold. It takes a week or two to actually get the resale certificate put together. You have to pay for that. So there's a little bit of a lead time in getting that information.
Yeah. So I've had a resale certificate denied twice that I can recall off the top of my head anyway. One was a 55 and older community where the buyer wanted to purchase in an LLC, and the association was like, your LLC isn't 55 years old, so no.
Yeah.
And so he had to purchase in his personal name to get over that hump. And then the other one was the seller, the homeowner, during the time period that they owned the home, they did a lot of improvements, very nice improvements, added a fence, added a patio, did all those things, but they didn't go through the proper approval process with the HOA. So they denied the resale, and we had to jump that hurdle to get everything approved. That was done.
Yeah, and I'm glad you brought that up because that is another, you mentioned at the beginning, sort of pitfall or something that could kind of throw a deal off course. These resale certificates, you just don't know what what the issues are until you get them.
Yeah.
Obviously, if you're familiar with the property, it was, maintained in accordance with, the deed restrictions that apply to the property, you generally would be confident that you're going to have no issues. But for, estate executors that aren't really familiar, don't really know much about the property or what the deed restrictions are, you might get a resale certificate back that says, this needs fixed, this was not done, this was not approved, you got to remove this. There's past due assessments, and when you get that document and provide it to the title company and the buyer, it's going to just create delays and
Mhm.
red flags potentially in the buyer's mind of, I'm not proceeding until all of this gets addressed. And um, that's really something that can really throw a deal off course. And that's why it's important to understand what all affects the property going into a sale, so that potentially in the contract or agreement, you're one step ahead before you sign, knowing that there might be this deed restriction issue or there might be this HOA issue out there. You can let the buyer know ahead of time and figure out how to deal with it so that it's not at the closing table.
Yep, 100%. Yeah, I have a transaction right now, actually, that we're in the trying to negotiate a short sale with the lender. But if that gets approved, then we have to negotiate with the HOA because this home has been vacant for over a year now. And since then, like, there's peeling paint along the window that HOA wants fixed. The grass hasn't been properly maintained. The HOA wants fixed. The deck needs cleaned. The HOA wants fixed, and they're fining the property every week until those items are done. So we've accumulated, a pretty hefty amount of fines over this time period, and we'll have to see, like, try to negotiate to get that paid from the proceeds of the sale. If the bank would allow it. I don't like it's a whole thing that we have to try to figure out how to overcome. But that's, I mean, it could hold everything up.
And not to belabor the HOA point, but that it just goes to show that there are all sorts of things that can come up, whether or not the property met these requirements. Oftentimes, there's also a discussion with these HOA documents are not always the most clear. So I've even seen situations where the HOA has come back with things, but as a seller and as maybe a seller's attorney, I look at the documents, I'm like, that is not actually the seller's responsibility per the documents. That's actually on the HOA to do through the assessments that they've collected. So
Mhm.
you can sometimes push back or have discussions with them and try to work out a solution if you have a good argument for it, which is why it's good to have an attorney assist you with that. The other thing I'll say too, not just in the HOA perspective, but just generally, is insurance issues are another thing.
Mhm.
It's important that you make sure that all your insurance is up to date, addressing, the fact that it is in an estate, that all the premiums are paid through closing, because if something were to happen to the property prior to closing, most of the agreements basically give the buyer the ability to walk away. And you don't want to be stuck in a situation where you don't have insurance coverage because it lapsed, or as an executor, you haven't been keeping up on it, or maybe the person who passed away didn't keep up on it. So again, making sure before you list the property that you have that in order, and that you have insurance coverage through the date of closing. That's important as well, because
Yeah.
the default and sort of the way the contracts are written in Pennsylvania law is that the risk of loss, they call it, is on the seller through settlement. So you want to make sure you have insurance to protect if there is damage or destruction to the property that occurs, before closing.
Yeah, that does cause confusion sometimes. I get sellers that once we agree to an offer, they're like, "Okay, well now I'm done paying utilities and I can turn the water off." Like, whoa, whoa, whoa! Like,
No,
not
yeah,
yet.
yeah,
You still have
yeah.
to maintain everything.
Yep, exactly. And it's further complicated by these HOA situations, for example, where there may, like in a condominium, oftentimes there's an association master policy, and so it's actually not on the homeowner to ensure, the exterior of their home. It's on the HOA to do it. So just kind of thinking through those finer details is important, and that's why you want to have a good team on your side.
Yep, absolutely. Yeah. So then I think the next step then would be if the buyer is getting a mortgage, typically there's going to be an appraisal. Sometimes it can get waived depending on how much they're putting down, but for the most part, there's going to be an appraisal process.
Hmm.
And going back to like turning the water off, I've had that where they'll turn the water off, and then the appraiser comes through and like, well, these sinks don't work, the toilets don't
Yeah.
flush, and even if it's like a boiler for heat, now you don't have heat in the home, so they'll deem it unlivable, and Freddie and Fannie will not lend on an unlivable home, which means we got to get the water turned back on and get the appraiser back out there to confirm like, no, we do actually have utilities. So yeah, I think that's something that I've seen in the past as like a big stall.
Yep, very true. It's making sure you have all the utilities and kind of generally the contracts will say you have to have all utilities on for inspections and appraisals. You have to keep the property generally in the same condition throughout the agreement period until closing. So you can't go and like materially change something. You can't just decide that you're not going to pay or you're going to turn something off that could, affect the condition of the property. So there are ongoing seller obligations that have to be adhered to after the agreement is signed. It's not like you can just walk away from there.
Yep. Yeah. So if the appraisal comes back at or above the agreed purchase price, no problem with that. But let's say the opposite happens, where it comes in at a lower value than the purchase price. What options will the buyer and seller have to move forward?
Again, that's where you run into, the negotiation. You'd have to amend the agreement to deal with, either seller assist or a purchase price concession. There's
Mhm.
different kind of structures for that, and that's why, again, it's always good to have a broker, an accountant, kind of advising you on that, as well as an attorney who can document it appropriately, because there are different implications on whether it's a purchase price reduction or a seller assist at the closing can kind of vary. But those are kind of the main things that can affect it. So I would say it's again going back to the table, negotiating an amendment, figuring out what makes sense for both parties. It goes without saying, because we've mentioned this before, that there's a spirit of collaboration there, hopefully, that
Mhm.
you're not going to let the deal die over this, and you'll try to work to overcome it. I don't know if that's kind of similar with what you've experienced as well.
For the most part, absolutely. I
Yeah.
was seeing back in like 2021, 2022, when competition was very high and the inventory was extremely low. I was seeing people coming out of pocket to cover the
Hmm.
gap. So
Hmm.
if the appraisal came in low, they would pay the extra 10 or 20,000 to cover that. Now that competition isn't quite as intense as what it was back then, I'm not really seeing that anymore. People want to pay market value for their property.
Yeah, and are you actually, speaking of that time, because that was a crazy time,
It was.
are you seeing as much of the buyers sort of coming in to be competitive and like being way over and waiving inspections? Because that was a big thing too.
Yeah, back then that was huge. In order to compete, I mean, oh my gosh, I could put a property on the market on a Friday, and by Monday I would have literally 30 or 40 offers in one weekend. It was insane. So how can you compete with that? You're going to waive your due diligence. You're going to go way above asking price. It was nuts. It's not like that anymore. If it is a competitive property, meaning it's like move-in ready, no issues, it looks desirable in a desirable neighborhood, you might have 2 or 3 offers to compete against. But for the most part, there really isn't that much competition. So buyers are coming in right at ask. I'm not really seeing them come in under ask unless it wasn't properly priced. But for the most part, they're coming in right at the asking price and asking for inspections.
And going along with that, I think that is another piece that I always advise clients when they are reviewing offers from a legal perspective. Something that don't always just look at the price. There's other factors in the agreement that can impact whether or not one offer should be, favored, or you might be more likely to accept than another one other than price. For example, how many inspections have they, selected? Basically looking for ways and contingencies that the deal could go awry, right? Because as the more contingencies there are, the more inspection rights there are, the more kind of what ifs there are, can lead to more complication down the road. So if it's a little bit more straightforward, but it might be a couple $1,000s less in purchase price, that might be more of an acceptable offer because there's less risk there. And ultimately, it does depend on the seller and kind of what their position is. But that's something I always tell clients.
I totally agree with you. The way I describe the inspection due diligence to my sellers these are more reasons they could potentially back out of the deal and not go to the closing table.
Yep. The other thing I would say too, just kind of talking through, other potential hiccups or things that can come up, going back to the timeline and sort of evaluating offers, depending on if it's like a quick close and maybe you're not ready, oftentimes you can negotiate as a seller, a post-closing occupancy period or move out period. And that's always something to keep in mind too, that you're not necessarily set on just accepting exactly what is presented. You can go back to them if you like the deal generally, but you don't maybe like the timeline. You can go back to the buyer through, a good agent like you or someone, your attorney, to just kind of figure out, hey, is there any wiggle room here? Can I maybe stay in the property for a month after closing just to kind of clean up, get the rest of the stuff out? Because oftentimes estates, maybe the executors from out of town, maybe there's not really a full plan on what to do with the stuff in the home, but you have a really good offer on the table. That goes back to the spirit of collaboration in hopes, if the buyer really wants the property, maybe they're willing to let the seller kind of have possession for a couple weeks, a month after closing. There's a document for that can be drafted. It basically kind of spells out the parties' responsibilities, and then that buys the seller a little bit of extra time.
Yeah, we don't recommend it be longer than 30 days, but absolutely. Yeah, and it really comes in handy if somebody has to sell a property in order to purchase their next one. So how it works if we don't do that is that you move out of your current home and all of your stuff is in a U-Haul truck. We go to the closing table at 9 a.m. To sell your current home. And then at 11 a.m., we're purchasing your next home. And then so you're living out of a U-Haul truck for that day. So by having that agreement and being able to maintain occupancy makes it a lot easier to transition into your next home.
Yep, exactly.
Yeah. Okay. So what about zoning? I know you deal with that too. Is that potentially so in my experience, when working with buyers, maybe they want to utilize the property for a certain purpose, like an Airbnb, or maybe they want to run a business out of it. So I've had zoning conflicts come up in those type of scenarios, but what else do you see that could potentially blow a deal up?
Yeah, zoning in a residential context, if you're dealing with an existing, home, it's generally the zoning issues are kind of few and far between in the sense of it's already an established property, and assuming that a buyer's just going to continue using it as their home, it's not really an issue. But to your point, where you run into to kind of hiccups is where the buyer may want to change the use, and Airbnbs are kind of the hot topic. Also, home occupations. I've seen situations where there might be a pole barn on the building, and the buyer has a business that they want to operate there. That's where you can kind of run into some issues because zoning ordinances, especially in residential districts, don't always allow for some of these ancillary uses. A lot of zoning ordinance are prohibiting, or at least don't have an ordinance that addresses short-term rentals, for example.
Mhm.
There's a lot of restrictions in zoning ordinances, typically with how much a home-based business can use of the property. So if it's like a large pole barn and it might be a little bit larger than even the house is, you might have trouble arguing that it's sort of a ancillary part of the property, and township might view it as kind of the primary use as a business, and that can run into the use not being approved. And if a buyer was kind of banking on having that pole barn for maybe their commercial trucking, their HVAC business that they wanted to operate out of, that's where you can run into issues. And that's why I always
Mhm.
recommend, um, you know, we're talking about from a seller's perspective, but the buyer should really be doing their due diligence about zoning up front. And if there is a zoning contingency that's elected and they find out that they can't do something with the property that they wanted to do, that gives them the ability to walk away.
Yeah. Yeah. I've also seen where they plan on putting up pole buildings and there's water runoff restrictions. So that can end up biting them too. So more things.
Yeah, the other thing, just kind of related to that is like setbacks. So sometimes if it's a weird, property shape and the buyer wants to put in, a pool or a shed or something, they may need to get zoning relief for that, and it might kind of extend the time frame. So just because there's a zoning hurdle doesn't necessarily mean the deal is dead, but it can extend the closing time period because the buyer might have to go through a zoning hearing or make
Mhm.
special applications to different boards in the township, that extend the time period until they're comfortable closing because they need that assurance about the use. Um, the
Yeah.
other kind of areas I see, hiccups kind of related to zoning is, I don't know if you probably deal with like clean and green, but that's another thing where there's notice requirements that have to be given when a property is being transferred, who the new buyer is,
Mhm.
and whether or not the buyer is going to actually continue the use of the property in the clean and green enrollment. So it's just important to kind of understand what your buyer is intending to do with the property up front. If the buyer is buying a farm, for example, that meets clean and green, but ultimately is going to tear down the house and subdivide it and build a whole bunch of a lot of lots on it, for resale, that could remove the property from clean and green. And you want to make sure that as a seller, you're protected from any rollback taxes or penalties that would occur from that.
Oh, that's great advice. Yeah, that's a good one. So, if somebody listening is an executor, power of attorney, or even a homeowner that's thinking about selling this year, what's one piece of advice that you could give them to check early to avoid certain problems?
I would say just, understand the property, know what you're kind of dealing with, and when you're going to list it and engage with buyers, just use it as an interview process to really understand the buyer, what it is that they're looking for, what they're planning to do with the property, as I just mentioned. Before you sign any contracts with them, just be diligent in understanding your buyer, the one that you're leaning toward selling to, so that you can try to kind of prevent some of these hiccups from coming up at the closing table.
Yep, good advice. So, before we wrap up, I want to shift gears a little bit. You are deep in real estate law all day long. What do you enjoy doing when you're not at work?
I like to be outside. I know right now with the weather the way it is, it's not happening as much as I would like. But yeah, I have, I live in Lancaster, so we're near a lot of good recreational spots, trails, the river. So I try to spend as much time outdoors as I can. I like to do stuff in the yard, gardening. I'm into like native plants and landscaping. So I find
Nice.
ways to spend my time outside to the extent I can. And that's one of the things I really like about doing real estate law is that you do have kind of that outdoor element in a sense. You get to know the land, the property that you're working with, and kind of get to know, all the ins and outs of it. So there's a tangible aspect there that I like, as opposed to, other areas of the law where it might be a little bit more philosophical, so to speak.
That's cool. So you have little ones, right?
Yes, I do. Two
And
girls. Yep.
how old are they?
I have a 5-year-old and a 2-year-old, and they definitely keep us busy. My 5-year-old
Mhm.
just started kindergarten, and my 2-year-old, it thinks she's in kindergarten, but she's still in preschool. So it's definitely a fun time, and it's sometimes a little hard to juggle, working and being a parent and everything, but you make it work and just try to enjoy those moments.
Yeah, that's awesome. Do they go hiking with you?
Yeah, they do. They love being outside as well, although sometimes they're a little bit more sensitive to the temperatures. It's like with young kids, I feel like the only time they really do well outside is when it's like 75, no humidity, sun, no breeze. Like they want it to be just like perfect weather. So if it's too hot, I hear something. If it's too cold, I hear something. So trying to
That's
get
so
them exposed to the elements as much as I can.
yeah, yeah, they're like the Goldilocks of,
Yeah, exactly. Yeah.
has to be just right. I love
Yeah.
that. And as far as animals go, you and I were talking a little bit ago, you have backyard chickens, is that right?
Yes, and so as a zoning expert, I would recommend again that if you're interested in having backyard chickens, oftentimes there are ordinances that address how many you can have, how big your property has to be. So you wouldn't necessarily think that that's a rule, but a lot of townships are kind of enforcing that. So yes, I have backyard chickens, and we like to get the eggs from them. We just have a small flock, but it's kind of an up and coming thing. I feel like a lot of people are
Mhm.
kind of going that way for one reason or another. Either they want to have the chickens or they want to have the eggs. But it's a lot of fun, especially for a family like mine with young kids. They enjoy taking care of them. And surprisingly, chickens are pretty smart.
Yeah.
They have each have their own individual personality, which is cool.
Yeah, my mother has backyard chickens, and she has four, and she will post on Facebook like one is super sassy compared to the other ones, and she
Yeah,
will always post what that sassy chicken had done for the day.
that
Yeah,
is funny, but it's so true. I can relate to that because each one has their own personality. Some are a little bit more timid. I have one myself that's also very sassy. It's just funny, and they kind of develop a little bit of a hierarchy of like one's in charge, one might be a little bit lower on the totem pole. So they're, if nothing else, they're very fun to watch.
yeah. Oh, I love that. Um, yeah, I know in Hanover, their ordinance, there is a restriction to the quantity. I don't know what it is off the top of my head. And you're not allowed to have roosters. Like they all have to be female chickens.
Yes.
And there was something else. Oh, and you're supposed to register them. So if you do have chickens, you're supposed to let them know and how many. I'm not sure what the registration process looks like, but I,
That's interesting. Yeah, they must track, like, maybe there's a permit or something. I know, like, in some of the Lancaster municipalities, they have something similar, and there's often a requirement of you can only have so many per acre. So they try to like limit the amount based on lot size. So and if you have like a small flock and a couple hens, they're really not very noisy, and people
yeah,
usually don't even know you have them. So
that's true. Yeah. Well, this has been awesome. So we did tell people to stick around to the end so that we can share what kills a deal, but I feel like we went through a lot of different scenarios on what could
we
potentially kill a
did,
deal.
yeah, it's really hard to pinpoint one particular issue. So I feel like we kind of peppered it throughout the
Yeah.
discussion and um, kind of walking through the timeline, the procedure for kind of a transaction from beginning to end, hopefully was helpful. It's hard to kind of predict what one major issue will be. So I tried to kind of highlight some of the ones that I've seen. I know you've expressed some of the ones you've seen. I think the biggest thing is that there's a variety. It can be a landmine of like
Mhm.
kind of figuring out where the wrong step could be. And that just goes to show that as a seller, you want to make sure that you have a good team on your side and kind of do your diligence up front on the buyer.
Yeah, absolutely. Well, this has shed so much light on how transactions actually go. I know a lot of folks, I mean, if you're not in the real estate world, like you don't realize all of this, but most people think that it's just, yeah, you find a buyer, you agree to a price, you close, and I get my money, and that's that. But there's a lot more that goes into it. So I'm glad that you were able to come on today and help guide us through that.
Yeah, I appreciate you having me, and hopefully the information and the conversation's helpful for people watching.
Now your firm does seminars, right?
Yes, we do. We have a real estate seminar that we do every year, typically in June. That gets posted on our website. I don't know that we have a date finalized for that yet, but that's open to realtors, individuals, corporations, anyone to attend. And we usually go through, we usually have a panel discussion as well as a couple breakout sessions about,
Nice.
different types of real estate issues. And each year we try to kind of take a poll from our attendees to see what they'd like to hear about next year so that we can kind of tailor our conversations to, the audience.
Yeah, I think that's amazing. Making sure that the education's out there for the community. I think that's great.
Yeah, it's a good event. We also offer realtor credits. So
Oh,
for people like you, when we did ours last year, we had a great attendance from brokers and realtors who just wanted to listen to us, but they also got credits for it for their professional
yeah.
certification. So
Continued education. That's awesome.
yep, yep.
Very cool. Well, thank you so much for sharing all of your expertise today. I really appreciate you coming on.
Yeah, thanks, Casey. I appreciate it.
Yeah, my pleasure, truly. So, for anyone listening, if you're dealing with inherited property, an HOA, or the sale suddenly feels a little bit more complicated than it should, this is exactly why having the right professionals truly matters. So, thanks for tuning in to Bodacious Estate Conversations. We'll see you next time. Bye.
Bodacious Estate Conversations isn't just chatter, it's about learning, taking action, and finding solutions that actually work. If today's episode resonated, share your thoughts, subscribe, leave a review, and pass it along to someone who could use a hand. More stories, smart strategies, and practical guidance are coming in the next episode. Don't miss it.